welcome back. I'm Sandra Nkobia, and this is the legal desk here on New Day. Now, we've been talking about termination of employment under the Labour Act, and yesterday we discussed grounds and procedures for terminating a contract of employment. This morning, we'll go into the forms in which the contract of employment can be terminated. And of course, as always, I have with me lawyer someone ever lovely, ever present, ever smiling with me to talk about termination of contracts of employment, the forms in which they take.
Yes.
Good morning, lawyer.
Good morning, Sandra.
All right. So without wasting much time, can we talk about the forms of termination of the contract?
When we go to the Labour Act, then the forms that a contract of employment may terminate. We have resignation by the worker, which we mentioned yesterday, death of the worker. Of course, that means that he's no longer available. We have dismissal of the worker by the employer, retirement of the worker, declaration of redundancy by the employer, and then mutual agreement between the employer and the employee.
Okay, so all of these are forms in which you can terminate.
Yes, these are forms. Yes.
Okay. What about the grounds for termination?
Right, when we go to the Labour Act in particular, when we talk about grounds, we have grounds normally under common law, that is the inherited law, but we have grounds under the Labour Act. And under the Labour Act, we have, first of all, mutual agreement, where does the employer and the employee just agree that enough is enough, we want to end. It may come orally or it may be written, but nevertheless, they agree that they are ending the contract of employment.
That's the mutual agreement.
Yeah, mutual agreement. Then the next one could be by ill treatment, where an employee, that's a worker, feels that he's being ill treated by the employer, or sometimes sexual harassment, and thinks that no, enough is enough, I can't work under these conditions. Then it may be a ground upon which a worker may terminate the contract of employment. Then we have death. I mean, that one, death is almost automatic. When the worker dies, there's nothing more you can do. But beyond death, we have medical grounds. That is where the worker is medically not fit. This one, the worker is around all right, but the nature of the work and his physical condition.
Okay, so who determines? Is it the employer or the employee?
In this situation, the employer, based on a medical report, a doctor may report that given the state of medical state of the worker, he is not capable of doing the work anymore, then it may be terminated.
Okay.
And then we have the very last one there. Yes.
What's the last one?
Yes, the last one there is about proving misconduct. Now, misconduct is the main ground that some employers terminate the contract of workers. But the law says proving misconduct. It must be clear. So it's not, you don't just get up and say that the employee has done something bad. We are thinking about things like stealing, things like...
Of course, misconduct will take various forms.
Yes, but it must be proven.
Okay.
All right. That's the word in the law. Proving means that you take the employer, the worker through a procedure.
Okay.
You hear him, and then you try to judge whether indeed he has a case or not. But don't just assume or speculation, and then you act. So the
rules of natural justice will kick in.
Exactly. So the emphasis there is the word proving. The emphasis is more on the word proving than the misconduct. Okay. In other words, you must establish that indeed the worker has.
So what kind of misconduct are we talking about? General dishonest behavior?
Yes, dishonest behavior, pilfering, insubordination, disrespect, drunkenness, late coming to work, not punctual, not regular, all these things that are just not proper as far as work ethics are concerned.
Okay.
That can be
but the key word here is proven. You can't just merely allege that.
If you want to terminate on these grounds, then you must give the worker the opportunity to answer questions, all right, and then if you think that he or she is still guilty, then you go ahead and do that.
Okay, so after all this has been established, what then is the procedure for termination?
Now, the procedure for termination actually depends on the ground upon which, but generally, it means that you give notice. It's very important. The law emphasizes a lot on notice. That is that whether the worker or the employer wants to terminate the contract, you give notice to the other party. And that, as soon as you give notice for a reasonable time, as the law requires, then you are okay. And if it is not notice itself, they pay in lieu of notice.
Okay, what does that mean?
It means that now, if I'm supposed to give you 30 days notice that I want to terminate the contract, but I want you to go now, then I pay you for 30 days work.
This is on the side of either party.
Yes, either party, whether the employer or the worker. But normally workers, they just run away. Workers will just throw you the resignation letter.
I can't imagine a worker saying, I won't be coming to work again, so let me pay you my 1 month's salary.
But sometimes it's important because you don't know where you are going next. You may
need a reference letter.
And the period of the notice is also important. But that one depends on the nature of the contract.
Right.
If it is weekly basis, then you give a week's notice.
Okay.
If it is monthly, then you give a month's notice.
Okay.
If it is by day, as they normally call it, then that one.
So it depends on your contract of employment.
Exactly. But normally, senior management normally goes with 3 months notice.
Okay.
Yes.
That's like maybe a standard.
Okay. Yes.
All right. How much money do you have to pay, or that depends on the salary that you are receiving?
It's been stated in the law. I mean, how much? Yeah. Okay. When the period. All right. So if it is 1 month notice, then you are giving 1 month pay. If it is weekly, then you are giving a week's pay, and that's important. Yes.
Okay. Is this the same as the remuneration for termination?
No, the law makes it clear that when there's termination, then the employer, the worker, must be given some money. First of all, you must pay him all the income that he has earned as at the time that you are terminating the employment. Now, if there are any deferred pay, that is that pay that you should have received long ago that you have not, then you must make sure that you pay him. And then finally, you must compensate him if it is respect of sickness or accident. Now, so normally, in terms of termination, in this termination, we are talking about the normal one, not the punishable one. You know, the one
yesterday we spoke about the dismissal.
But if it's not dismissal and terminating, then basically the worker gets all his entitlements, and then you must give it to him before he leaves the work. You don't let him go and later I'll send it to you. No.
Okay, you mentioned something about compensation.
Yes.
When does that come in?
Well, in case of sickness and accident, you know, sometimes.
And must this have been during the course of the work?
Yes, during the course of the work.
Sickness that you acquired outside of the work?
Normally during the course of the work. Okay. And then you realize that, well, you must terminate the contract on the ground of sickness. You are supposed to pay an amount of money for a period of time, at least, so that the worker can treat him or herself before.
Okay. Lawyer, what would we term as unlawful termination?
Unlawful termination, that's what really leads people to court. This is where the employer normally, though the employee may also do it, but this is where the employer has not complied with the necessary rules in order to terminate. And it can be 2 grounds. First of all, the ground upon which he is terminating is improper, or the procedure that he used to come to the conclusion is also improper. So one of these, then we describe it as unlawful. And normally it means that you have breached some part of the law. It can be that the contract itself, you have breached it. It could be the collective agreement of the company. It could be the Constitution or even the Labor Act. So if any of these laws give a procedure or ground for which you can terminate, and you don't follow the ground or you don't follow the right procedure, then we describe it as unlawful
termination. Is this the same as a wrongful or invalid
There are 2 dimensions of unlawful. Now we have the wrongful termination and then we have invalid termination, though both are unlawful.
Okay.
Now the main difference is the question whether the employee has been properly dismissed or not. In other words, whether the employee contract is subsisting or is dead.
Okay.
Right. Usually, termination ends the employment. Once there's termination, then you are supposed to be finished with the work. But if it is wrongful, it means that the termination is all right. You are no longer working there, except that because the procedure is not correct, you are entitled to damages.
Okay.
The employer must compensate you for not terminating the contract
in the right manner.
Right.
So it's unlawful, but it's also wrongful.
Unlawful means either wrongful or invalid.
Okay.
Yes. All right.
Okay.
Now, when we talk about the invalid,
so wrongful basically means that you're entitled to damages.
Yes.
Okay.
Yes. Okay. But nevertheless, you have been sacked. Let's put it more bluntly. You are no longer working there, except that now you can claim damages from the employer. I mean, more precisely, you can't ask the employer to bring you back to the workplace.
Okay.
And usually this would be for the private industry. I mean,
but you can get some sort of compensation.
Yes, that's if you pursue it to court and things.
Okay. What about the invalid?
The invalid is where, because the employer has breached certain procedures, the law assumes that the contract is subsisting. Okay. So that one, if the court comes to that conclusion, you will be reinstated. You understand? Because the termination was never done. All right. He attempted to terminate, but because it's invalid, normally because he has not complied with the procedure.
Okay.
And these usually apply for public servants. Okay, those under public law, whereby we studied earlier that there should be no discrimination or arbitrariness, etc. So if it is shown that the employer has terminated a contract in a manner that is contrary to the Labor Act or to any public law, then they will say that, well, the employee was never the contract was never terminated.
That means you're still an employee.
Yes, so then you'll be reinstated back to your position
if you want to.
Well, that's if you want to, but at least you have that right in law
to go back to.
But in the case of wrongful termination, you don't have the right at all.
Okay.
They may come to conclusion that you have been wrongfully, the contract has been wrongfully terminated, but all that you can do is to claim damages. You cannot.
Generally, what is the amount of damages that an employee is entitled to?
That is what, if you consider seriously, you will not advise workers sometimes to pursue. Normally, if you take action for breach of contract of employment, you are supposed, the court will reward you according to what you should have been given.
Your salary.
No, yes. What
during the period.
What you should have been given if you have been properly terminated.
Okay.
And like we said, if it's a monthly contract, then we are talking about a month's salary. And this one doesn't make economic sense. For instance, that you go and appoint a lawyer, you go to court, you fight for 1 year, 2 years, only to come to a conclusion that all that you deserve is 1 month pay that you were not given. So
what are you saying? They should leave it?
No, but
it's not worth the trouble.
Sometimes it's the court system that must improve. Like these things are hardly there. But that is why if you go through the Labor Commission,
it's
you
better.
can have it faster without going to court and wasting time and money.
Okay, that's all the time we have today.
All right,
thank you ever so much, as usual. Thank you. This has been the Legal Desk, and we've been talking about termination under the Labor Act. We'll be back tomorrow to continue. Stay with us.